So I want to just briefly talk about three things today. One is kind of the basic state of the branch. The second thing is the relationship between the court and the bar. And then just a few kind of closing thoughts on the big picture these days for judges. When it comes to the branch, I think our court, we always try to keep in mind sort of the two guiding principles that we have, which is service and excellence. We have been very blessed the last several years to have a legislature that's been very supportive of the branch. I don't want to take anything for granted because the governor still has his work to do reviewing the budget. But the legislature did approve and fund 39 new judgeships for the state this year, which is a huge number. And I guess, I think the important thing to keep in mind about that is that when the legislature makes that kind of an investment in the branch, I think they and the people, have a right to expect results. That it's not just a matter of kind of pumping more resources into the system, but that instead we're going to do our best and kind of do our part to make sure that things like hearing time and the processing of cases and just the basic service that we give the people, that there's kind of an increase on that front that's commensurate with the new resources that we've been given. And so I think our court has a responsibility not just to advocate for the branch to try to get those resources, but also to make sure that judges have the help and support that they need to do the job as well as I know you can. And so this coming year, we're going to be prioritizing trying to make the best case possible to the legislature to get some of the technological help that we need. The court is very cognizant of the fact that we've been making a lot of demands of trial judges and a lot of demands of litigants. And we think that that's for the greater good, but we also understand that in order for people to really be able to kind of live up to the expectations that we all have for ourselves, not just that the court has for you, but that all of us have for each other, that we need to give you the help that you need. So we're going to be focusing on that. We also have been doing a lot of work on the education front. Florida has a great court education system, and we want to just keep trying to make it better and better. Justice Sasso has kind of taken that project over. Justice Labarga did a great job for many years doing that. And we're really trying to focus on making sure that court education is geared toward things that are going to help judges do their job as well as possible. That are going to really produce kind of concrete results for how they're able to serve the people. All of us, I know, you wouldn't be a judge if you weren't kind of intellectually curious and intellectually interested in, learning new things about the law and that sort of thing. And there's plenty of opportunities for that, whether it's through, other educational pursuits or your private reading or whatever. But when it comes to the resources that we've been given by the legislature and that we want to invest in the judges as a branch, we really want to focus on things that are going to have kind of tangible, concrete results to help you do your job better. We know that, especially now kind of post-COVID with a lot of the remote appearances, that it's enabled practitioners to practice throughout the state more easily. And that in turn has led to sort of a greater awareness of a lot of the kind of inconsistency, not necessarily in a bad way, but just sort of the diversity of practices that different judges have around the state. And so one of the things that one of our work groups did this past year was come up with some kind of model templates that it's not mandatory yet to use, but it's definitely a best practice that we encourage, just to try to make each judge's kind of individual requirements for scheduling things or communicating with the court or how to get in touch with the JA, et cetera, just to kind of make that as easily digestible and findable, and if not uniform in terms of the content, but at least kind of standardized in terms of the way that it's presented to people. We also recently, up at the Supreme Court, went live with on our website. We've tried to compile all of the case management orders and resources from all the different circuits throughout the state, which, again, we're hoping that that will help people, especially those who practice, in more than one circuit. I think it will also, maybe by bringing it all together, maybe foster some thinking about kind of best practices. And, we realize that we've tried to initiate a lot of changes in the last few years, and we also, as we always stress when we talk about this, we know that it's a work in progress. We know that we're all going to have to, as a system and as judges and attorneys, we're all going to have to keep learning. And, the more transparency there is in what the different circuits are doing, then hopefully that will spur conversations among the attorneys and among judges, and eventually, hopefully, we'll end up with the best product possible for the people. And then finally, we recently put together a group that's under the leadership of Chief Judge Lance Day to focus on judicial security, kind of personal security of judges. That's obviously something that, it's unfortunate that these days that seems like there's kind of a need for greater awareness, a greater, knowledge about what we can do to try to keep our judges personally safe, whether it's, maybe it's resources that we might need, maybe it's more communication between the circuits and local law enforcement, maybe it's just helping judges kind of educate themselves about, common sense, but maybe not sort of intuitively obvious things that they can do to protect themselves. So we're hopeful that that work group will come up with some good ideas, and we commit to all the judges that whatever we can do sort of on our own, we'll do. Whatever requires working with the legislature, we'll do that. And we want to, obviously we owe it to the judges to do the best we can on that front, and so we want to be kind of leaders in that area. The second thing is just kind of our relationship with the bar. I really treasure our relationship with the bar. I think, my entire time on the court, we've had a great partnership with the bar. We have emphasized trying to keep the bar kind of focused on the core mission of helping the court to regulate the legal profession, help with the rules, create an environment where everybody, all Florida lawyers know that there's kind of equal concern to us and to the bar, and equally kind of welcome to participate in anything having to do with the bar. We recently asked the bar to stop the historic practice of making voluntary appointments to the ABA's House of Delegates. We did that really to try to be consistent with what we asked the bar itself to do, which is to try to stay out of controversial public policy matters. And we also do it just out of respect for the membership. We're acutely aware of the fact that to practice law in Florida, you have no choice but to be a member of the bar. Obviously, you get a lot out of that as a lawyer, but we think that one of the things that you don't sign up for when you become a member of the Florida Bar is to, basically sign on to, controversial public policy views, that you might not agree with. And obviously, what's controversial is kind of in the eye of the beholder. What each of us, thinks is good or bad policy is a very subjective thing. And I understand that there are going to be some close calls on the margins of sort of what we could maybe agree, or kind of within the core of, what the bar exists to do. But I think that there's lots that voluntary bar associations and groups like the ABA engage on, that I think, regardless of the merits of what anyone might think about a position that they might take, I think any reasonable person would agree that it's, certainly outside the core of anything that the bar would do directly. And then, outside the core of what is really directly related to kind of helping the legal profession, and is more oriented toward people's views about kind of what would be best for society at large. And there's a long tradition of lawyers being at the forefront of those debates about public policy and what's best for our society, but not in the context of of having those views and those ideas basically be attributed to people who are, who don't have any choice but to be affiliated with the group. And so, we understand that making appointments to the ABA House of Delegates it's a bit attenuated, where nobody thinks that everything that the ABA says or does can reasonably and fairly be attributed to the Florida bar. But at the same time, if the ABA itself is doing things that our bar would never do, and if there are still opportunities for Floridians voluntarily to participate in the ABA and get involved with the ABA and advocate for whatever they think is in the public interest and the common good, we encourage that. We just think that it's something that, we think that we will be stronger as a bar, and frankly more sort of legitimate as a bar if we stay in our lane and let people kind of pursue their more kind of tangential to what the bar is for, pursue those things kind of on their own. So we think of it as really just a basic matter of respect for the membership of the bar. I understand that that's not something that people universally agree with that perspective, but I just want folks who care about that to kind of hear it directly from me as to sort of what our thinking is on that. Also related to the ABA, we have a project underway to look into the current requirement that someone attend an ABA accredited law school in order to be able to sit for the bar. I think a lot of, there's been some interest in that project, and there's some other states that are undergoing similar reviews, and we'll see how that plays out. That's obviously a complicated thing. The one thing I want to make clear to everybody is that the point of that project isn't for the court to sort of directly be involved in the regulation of law schools, or for us to sort of meddle in whatever the ABA's own accreditation decisions might be, or a law school's choice to want to be accredited by the ABA. What we feel like we have a responsibility for is, to the extent that we have made attendance at an ABA accredited school kind of a requirement to be able to sit for the bar, and to the extent that we are responsible for, controlling the admissions process or helping the bar examiners do that, we've sort of delegated some of our authority and some of our sort of discretion to the ABA. And so I think it's fair to look into that and see whether that still is a wise thing for us to be doing. And so former Justice Polston is chairing that group from us. We've got Dean O'Connor from FSU, several other people, former bar president John Stewart, who I think he's a great guy. I've loved working with him, and one thing that I appreciated about him, his tenure as a bar president, was his interest in kind of innovation, and we thought he would be a kind of a really valuable member of that team. So we'll see how that goes, but I just wanted to kind of give you an update on that and what the purpose of it is. And then finally, just sort of the big picture, sometimes, I don't think that this year is unique, because I remember I sat next to Judge Altanaga a couple of years ago and talking about, a similar thing about sort of controversial issues with courts and a lot of public interest in courts and a lot of big debates about separation of powers and individual liberty and kind of institutional competence and authority and all that sort of thing. And the specific issues might sort of change year to year, but those types of debates that we have, I think, are just always going to be with us, and it's part of, I think, what makes it so rewarding and exciting to be in the judiciary, is that we do get to be participants in those debates. But I think that at times like this, where there is so much scrutiny of courts and so much conversation about it, and some of it sort of measured, some of it kind of more kind of characterized by rhetorical excess and people kind of exaggerating things to make their point and everything. I think that in times like this, it's even more important for us to just focus on the fundamentals, especially those of us who are judges. And I think fundamentals kind of in two separate areas. One is kind of just our role and the separation of powers and sort of what we're here to do. And then the other way is just sort of the judicial virtue, the qualities of a judge that make one excellent, kind of the habits, the dispositions that we can, that we have a choice to think about and to actively cultivate. And so rather than have you guys have to hear me pontificate in my own words about these things, I decided I would just read a couple of passages from the first code of judicial ethics that was written originally in the 1920s by a small group of people that was chaired by Chief Justice Taft. And these were the canons that were in effect until the early 1970s, at which point I think there was a sense that we needed canons that were maybe more rule-like and more susceptible to being used as the basis for discipline. And I think, we gain something with that because, it's more clear. It's, if someone's going to be charged with misconduct, it's more, it's more knowable sort of what the expectations are. But I do think that we lost something in terms of articulating what we're trying to do in a more kind of aspirational sense. A code of conduct that you're going to use as the basis for disciplinary measures is obviously going to be more of kind of a lowest common denominator than something like this that kind of reminds us about more sort of what we're striving for. So on the issue of the separation of powers, I just want to read this one paragraph. A judge should be mindful that his duty is the application of general law to particular instances, that ours is a government of law and not of men, and that he violates his duty as a minister of justice under such a system if he seeks to do what he may personally consider substantial justice in a particular case and disregards the general law as he knows it to be binding on him. Such action may become a precedent unsettling accepted principles and may have detrimental consequences beyond the immediate controversy. He should administer his office with a due regard to the integrity of the system of law itself, remembering that he is not a depositary of arbitrary power, but a judge under the sanction of law. So that kind of speaks to the perennial challenge that we have as judges, which is, how do you achieve justice in the individual case while at the same time remembering sort of where we fit into the system, who gets to make the basic decisions about what's just, et cetera, and reminding us judges that we are just as constrained by law as anyone else. And then when it comes to kind of the personal qualities of a judge, this is another kind of short paragraph. And I think it's actually, to read this paragraph, to me, I find it both very inspirational and very daunting at the same time. Because I know, speaking for myself, I try to be the way this paragraph talks about, but I don't always succeed. But I think that that's part of what makes being a judge kind of not just a professional adventure, but a moral adventure as well, because it demands a lot of a person. So I'll just read this paragraph. In every particular, his conduct should be above reproach. He should be conscientious, studious, thorough, courteous, patient, punctual, just, impartial, fearless of public clamor, regardless of public praise, and indifferent to private, political, or partisan influences. He should administer justice according to law and deal with his appointments as a public trust. He should not allow other affairs or his private interests to interfere with the prompt and proper performance of his judicial duties, nor should he administer the office for the purpose of advancing his personal ambitions or increasing his popularity. So that's a lot to live up to, and I think it's a beautiful thing to strive for. As I said, I would encourage all of you, if you're interested, to kind of find these old canons and read them and reflect on them. It's a lot more inspirational than, don't lie about your opponent and your race, or, don't do whatever the sort of lowest common denominator is that we see in, the more modern code of judicial ethics. And so I just want to conclude by, I know the focus of this lunch is on the judiciary and the state of the judiciary, and I just want to thank all of you who are in the judiciary for what you do. I want to thank all of you who care about the judiciary, and whether it's constructive criticism, or if you think that we're doing a good job or whatever, we need people to care about the judiciary and help us do the job as well as we can, with the ultimate objective, which should guide everything that the bar does and everything that the judiciary does, which is to serve the people of Florida as well as we can. Thank you.